The focus of this episode is instructing or using tax barristers as tax professionals. We are joined by three guests from Devereux chambers who demystify key jargon on the topic, explain how instructing works, and give us an overview of how barristers typically help tax professionals and our clients. You're listening to episode 95 of the Tax Professionals Podcast, the podcast that helps tax professionals to progress, develop, and improve their careers.
Welcome to the Tax Professionals Podcast, the podcast dedicated to helping you improve your tax career. Here's your host, Jack Bonehill.
Hi everyone, and welcome to this episode. In all the podcast episodes to date, there's only been a handful of times where I've had more than one guest join us. And from memory, one of the CTA episodes had two guests, and I did an episode for International Women's Day a few years back where we had three guests. There might be more, I can't remember about looking, but this episode adds another to the list. We're joined by three guests in this episode, all from Devereux chambers. We have Max Schofield, a tax barrister, Billenness, Director of Clerking and Business Development, and Aparna Nathan KC, tax barrister. They each give us an introduction of themselves at the start of the episode, and so I won't jump the gun there. This episode centres around the topic of instructing a tax barrister, and from the episode you'll get to understand what instructing a tax barrister is, the situations where you or your client would benefit from instructing a barrister, the process for instructing one, and how you can go about finding the perfect barrister for you or your client's circumstances. Rough timings for each section of the episode can be found in the details section of your podcast player of choice, or by heading on over to the show notes for this episode at thetaxprofessionalspodcast.com/TTPP95. If you're interested in the barrister and the legal side of working in tax, then I can also suggest that after this episode you take a listen to episode 51 with Alice Kemp, which is about criminal HMRC investigations and typical mistakes that tax advisors make. And there's episode 59 with Harriet Brown, which is an insight into how to become a tax barrister. And both of these guests, would you believe, actually have their own podcasts too, also centered around tax. And links to both of these episodes are in the show notes. Being able to figure out the answer to a tax problem or query, regardless of the situation, in my opinion, is a fundamental career skill for any tax professional. But it is also one of those areas that many people find difficult and over-rely on their colleagues for, hindering their own progression. It's not surprising. The right legislation and HMRC guidance can be hard to find, and then once you find it, you have to analyse it and understand it, which can be time-consuming. And helping you get past these barriers, learning how to do these things well and quickly is exactly what the Tax Research Masterclass is all about. Past attendees have told me how much quicker it's made them at finding the right resources and then getting to the answer, to the extent that these people have become known as experts in doing this in their firms or teams. I'd love for you to let me help you too, and the full details for the masterclass can be found at thetaxprofessionalspodcast.com/masterclasses. And the next one is in May 2024. So I can suggest that you take a look at the details, and if you are interested in attending, with your employer covering the cost and time, importantly, feel free to message me, and it may be that I can help persuade your employer to do exactly that. But in any event, I hope to see you or some of your colleagues there. And just before we jump into this episode, I've got some pretty big personal news that I'll get to share with you all soon. I'd love to tell you about that right now, but I know that the best thing to do is wait until the start of April, which actually isn't that far away now, so do bear with me. And apologies, I do know that that's a bit cryptic, and you'll understand why once I share it with you. But in the meantime, let's get to this episode. It'll be nice just to get a little bit of an introduction about you all. So if you don't mind starting off with Max, that would be great.
Yes, hi, I'm Max Schofield. I'm a barrister specialising in indirect taxes. So from mainly VAT, but including sort of gambling duties to soft drinks industry levy and everything in between. Most of my time is spent on litigation, so matters in dispute from initial uncertainty with HMRC that might never get to court, all the way through to appearing in courts and tribunals on appeals.
Over to you, Aparna.
Thanks, Jack. I am a barrister specialising in tax law. I was appointed as Queen's Counsel in 2019, and when the Queen sadly passed away, I was appointed immediately as I became a King's Counsel. I specialize in tax law, both advisory, so that's when you want to set up structures or you want to ask what is the meaning of what this will or what's happened with this trust, all the way through to litigation. I'd handhold through inquiries, and then eventually, if the revenue don't want to back away and you can't get to a settlement, then I can also litigate for you. Litigate is a word we're going to come to later on.
Over to you, Glenn.
Hi, yeah, my name's Billenness. I'm the Director of Clerking and Business Development at Devereux. I've been a clerk for over 25 years, and 18 of those years have been spent here at Devereux. I was recently appointed the director last year, so my role's changed slightly. I now manage the clerks room and look after my members as best I can.
So I think most people know what a barrister is and what they do, but I don't feel like as many people know what clerking is. Could you just give us a little bit of a flavour of what that actually is, Glenn, and what you do?
Yeah, every barrister's chambers will have a clerks room and a clerks team. The clerks function is essentially to run the professional practice of their members. The clerks function includes diary management and counsel for particular cases, fee negotiation. And some of the senior clerks, there's quite a large element of marketing and business development aspect to their role as well. The clerks tend to be the one that liaise with their instructing solicitors before it gets to counsel. So the clerks play quite a key role in the barrister's chambers.
Yeah, no, it sounds like, yeah. I didn't appreciate how broad the role was previously. I knew that you dealt with fee negotiations and putting people in touch with the right barrister. I didn't know what else was included in the role.
Yeah, it's quite an involved role, and it's evolved over time. As I say, I've been in clerk for over 25 years, and it has changed a lot. There's a lot. The higher up you go and the more senior clerk you get, the marketing and business development and actually developing work opportunities for your members becomes quite a big aspect of the role.
I'll just set the scene a bit for this episode then. So Max got in touch with me, I want to say 3-4 months ago now, maybe even longer. I think it would be good to get Devereux onto the podcast. And when we were talking, Max suggested that we could talk about like instructing barristers and what that means and how it all works. And that sounded like a pretty good idea to me, because I feel like for a lot of tax professionals who aren't legally trained don't really know anything about that world. And I know a little bit because I've been somewhat involved with some clients, but like my knowledge is still very limited as well. So those who haven't been in that position will have no idea about what any of this means. But yeah, that topic about talking about instructing barristers, what that means and everything around that is going to be what we're going to talk about today. I think a good place to start would be in terms of like the terminology, like what actually is instructing? What does that actually mean? Because I think it's somewhat jargon, and people outside of the profession, or even those who work in tax but are not legally trained, won't really know what that means.
Yeah, Jack, I was going to say, when we originally discussed the possibility of doing the podcast, obviously I told you you've accompanied me on many of my walks around Richmond Park in the morning. And obviously you have a very diverse clientele, group of guests. Normally accountants and tax advisors quite focused on their business structures and their qualifications, which I always thought was quite useful, sort of glean information and transferable tip from them with the varied perspectives. But obviously there hasn't been anything particularly litigation or barrister based. So I thought it might just be useful to add to that corpus of knowledge. With regards to instructing a barrister, it's probably best to go back to the basics, really. We have a split profession in this country. Lawyers are divided into barristers and solicitors. Although the pathway to qualification and the regulations have a clear divide, these days the work that's undertaken will actually often overlap. The distinction's been around for hundreds of years, I think sort of 13th century odd, where we had sergeants of law and attorneys. But it used to be the case that broadly barristers would be advocates. So only barristers were granted rights of audience, which means that they're the only people who can be heard by judges. And usually they'd have a sort of somewhat narrow specialism. But crucially, they could only be engaged by solicitors. They could only be instructed by solicitors. So they had no lawyer-client relations. All the work had to come through what was called the instructing solicitor. And this means you couldn't advertise for work, you couldn't handle any client money. A key factor for the bar and being a barrister has been and still is that we have to follow what's called the cab rank rule. So if we're asked or instructed to represent someone, we can't refuse to do so on the basis that we don't like the client or their beliefs. We must argue their case as fearlessly or forcefully as the client would do, but just with some legal training and experience. And that cab rank rule is, for those who don't know, comes from the Hackney Carriage black cab rule. They take you anywhere you want to go if they're applying for hire. On the other side, solicitors normally have a broader remit, multiple areas of expertise in which they work. They can obviously choose whether to work or whether not to work for a client. And they might deal with various affairs of many clients, everything from drafting contracts and wills to advising on sales or property or divorces. If there's a sort of particularly niche problem or something unusual that might end up in court, they'd normally instruct a barrister to advise or represent the client. There's a misnomer or mischaracterization that solicitors are like general practitioners, but that certainly isn't the case today and probably wasn't really the case historically either. These days you find very expert specialist solicitors and more generalist barristers, and some solicitors have rights of audience as well now. And you'll find barristers who do purely advisory work who rarely go to court, only in facts. So yeah, to the extent there is a difference, the lines are potentially more blurred. I'd say what is true as a trend, even if not a rule, and we know as tax lawyers that all the rules have exceptions, is that barristers are normally very adept in litigation. So that's bringing disputes to court, from strategy to procedure to argumentation. I think most of us would consider ourselves to have expertise in that litigation process. That's sort of backed up by the fact that barristers' vocational training is concentrated on court procedure rules and public speaking. And of course, we're in front of judges fairly regularly. We get acclimatized to the confrontation. We know what arguments might be propitious or not and how they may be deployed. Obviously, that doesn't always lead to success. Every case is winners and losers, but it means we know how to give the case of its best shots. So that's a broad background of the split profession. It gives us some idea as to how to answer the questions: what is instructing a barrister and what are instructions? Barristers were commissioned by solicitors to do specific tasks on behalf of the clients without the ability to turn it down unless they were unable to do it. So that broadly accords with the meaning of instruct, to tell someone to do something. Now, I'm not sure whether Glenn would be the best place to talk about it, but things have changed now. We have something in the last 20 years called license access. That means that accountants who are regulated by large regulatory bodies can actually instruct barristers directly and ask them to do work without the need to interpose a solicitor. So they can draft what we've called the instructions to counsel, which is a document telling us what the problem is, what they want us to do about it, giving an advice or an opinion or to represent a client. And they can now do that directly.
Okay. That's actually, I didn't realize that then, because I always thought the word instructing sounded a bit too like, you must do this, but that's because obviously that's where the history lies with it. Then you did have to do it when you were instructed in the past. I didn't know that.
Well, that's still true now. The cab rank rule still applies. Obviously, there are exceptions to it. If you're too busy, you're on holiday, maternity leave, then obviously you wouldn't be expected to do it. But generally speaking, if a brief comes in our name and says we want you to do this, we can do it. We have to do it.
Mm-hmm. What about the term litigation then? So that's the only other term that I think is a bit of jargon when it comes to barristers and instructing and understanding what they do. So what really does litigation mean?
Is the end of a series of steps. So you tend to have in tax, you tend to have a person who puts in a self-assessment return, say, and then the revenue may or may not open an inquiry into it. And they have a specific, there are specific inquiry powers within the statute for the revenue to open an inquiry. Sometimes they don't open an inquiry, but they become aware that there may have been an amount of tax that was due that wasn't included in the tax return. So they might issue a discovery assessment. What they can do is ask questions, whether in the form of formal inquiry or in the context of general inquiries that then lead to a discovery assessment. When it is not possible to satisfy the revenue in the course of that correspondence and any meetings that follow it, that actually that no tax has been left out that should have been paid, then the revenue basically issue a closure notice or a discovery assessment, as the case may be, depending on the procedure, and you end up in court. The court in this case is in fact the first tier tribunal for most cases. So when we argue our case and the revenue argues their case in the FTT and upwards, that is called litigation.
Mm-hmm. So bringing it into my world a little bit then, because I work in employment taxes and there's no statutory powers for HMRC to do an inquiry into like a specific piece of employment taxes. It's done under like Schedule 36 notices. That's really the only formal route for them to get information in my area. So at the point that an assessment is raised, say, and an appeal is put in, is it from the point that the appeal is put in that's classed as litigation, or is it before, or is it not quite that simple?
it's not quite as simple because you might already be in dispute with the revenue, i.e. it's contentions even before it gets to litigation. So there's your litigation covers certainly being in court and tribunals, but it can also be the run up to it, but not, I would have said, the opening of the inquiry and the correspondence in relation to that.
Okay. Do you think it's the point where there's some form of dispute or disagreement? Is that the point onwards that you potentially class it as litigation?
That's how I would regard it, when really it's the point at which you start thinking, how do we resolve this dispute? Do we go down the ADR route, the alternative dispute resolution, or do we end up in the tribunal arguing it adversarially?
Yeah. Do you think that's why? Do you think that definition of litigation is wider than what it would have been in the past? Because obviously ADR is relatively new, right? I know there would have been different mechanisms in the past that were similar, or if not the same, just under a different name. But yeah, do you think it's extended over time to be more than just court, or has it always been like that, would you say?
I think the concept of litigation has been limited mostly, I would have said, to the run up to and court. But with, as you say, the court's desire for an alternative dispute resolution, we tend to find that you tend to have the two parties showing up in a different space in order to try and settle a dispute. The tone of that and the temper of that, and whether it really is adversarial or really seeking a negotiated settlement, will depend on the arguments so far and the way the parties have interacted so far.
Mm-hmm. You touched upon this, Max, when you were talking about something earlier, because you mentioned advice, opinions, and representation. Those are the three areas that I always think about, I suppose, in why a barrister might be instructed. Does that cover everything, or is there anything else that could potentially be you could potentially be instructed to do?
I think those are fairly broad terms. They probably do encompass most of the work we do. To give some more concrete examples, we might be instructed to advise on a policy matter, so new legislation coming into force, or the effects of a change in policy, or an effect of a change in the legal precedent. So it can be something slightly more abstract and holistic, or it can be something very specific. What does this client have to do with regards to this specific issue in which they're facing? So there's a very broad remit. We normally distinguish between contentious and non-contentious. So the contentious stuff is more towards the litigation where there's something adversarial, and the non-contentious is basically trying to make something work rather than when something's broken down. That's how I conceive of it. I'm not sure whether Glenn or Aparna have any other views.
No, I think I agree with you, Max. I think that's broadly how I tend to split it out. With tax, one tends to have both aspects. You've got people trying to forward plan for their children, for their businesses, for their estates, so to have intergenerational transfers of wealth. That generally takes place in the advisory non-contentious field. And of course, if things go wrong, it can end up in the litigation field. But litigation tends to be where it's generally the revenues on the outside, and you haven't been able to agree in correspondence or in meetings with them what taxes in fact due.
Mm-hmm. This is just on the back of something that you said, Max. It just made me think this. Would you ever have a scenario where, say, an accountant or a tax advisor has a bunch of clients with a similar scenario, and that accountant or tax advisor has a great interest in, say, a particular rule or the application of it in certain circumstances? Would they ever instruct you to say, like, what the general gist is of those rules or how it might apply in those circumstances, and then they then use that, I suppose, to advise their clients? Is that something that ever happens?
Absolutely, yes. And we have our professional obligations to the client that we're representing. So we don't normally provide a sort of general view that anyone could rely upon. But I've certainly had numerous instructions back from people who might represent trade bodies who want us to have some sort of guide to law, legislation, or matters of interpretation, and that they will then go and share with members of their trade bodies or their own clients. Mm-hmm. Glenn obviously sees all the different instructions and briefs coming into chambers, so he might be better placed to stand upon that.
Yeah, as Max says, we see quite a lot of a broad spectrum across all the tax cases coming into chambers. And at Devereux, we're quite fortunate because we've got quite an extensive team that cover all sort of aspects of both direct, indirect tax. We deal with sort of domicile, residence issues, transfer abroad, inheritance tax. Max touched upon sort of the VAT and customs and excise issues that he deals with. And our team is growing as well, which is for Devereux.
Yeah, and to add to what both Glenn and Max said, yes, when new legislation is being proposed nowadays, we tend to have it announced in one of the budgets in the year, and then we tend to have draft legislation sent. And clients often want to understand how it's going to impact their structures that currently exist, or how it might affect adversely otherwise their proposals for the future, for the way they want their business to work, or how they want to transfer wealth into generation, whether through trusts or through partnerships. So yes, they do come to us for broad advice on their circumstances of things that might come into law. Does that answer your question?
Yeah, it does. Do you mind if we just delve a little bit into the opinion side of things? Because that's where I've personally had the most involvement and experience with barristers, is around opinions. And I think before the first time I was involved in that, I would have had no idea really what it was. So do you mind just explaining a bit like what actually opinion is and what the benefit is then for people?
The benefit is that you get a view from a specialist in the field, usually with several years' experience, or even if not with several years' experience, with in-depth experience in a particular field, so that actually the number of years of involvement doesn't much matter because they really understand this field. And what you get is bespoke advice for your circumstances. So you can see how the proposed law is likely to affect you. It gives you clarity, and then you can build your world accordingly.
Because obviously there's a lot of areas of law that's somewhat subjective. And do you ever get cases where someone will come to you and ask for your opinion as to whether they've got a reasonable interpretation, even if it's not necessarily the interpretation that you have, but is it reasonable? Does that ever happen?
Yes, all the time. Because interpretation, certainly statutory interpretation, and we're very fortunate tax have a statutory backbone. What tax did was actually create the law. And so all of it has been statutory. What the words mean, obviously, is open to interpretation. And that's where the courts and their guidance through their various decisions come into play. For instance, most recently, we've had the Supreme Court decision in Fisher back in December, just Christmas, about legislation that's been hotly debated since the 1990s, I think, when the first lot of transfer of assets provisions came in. And it's still up for grabs what is, less so what is the transfer of assets, but more so who is within the scope, is there double taxation? So you can have different views on how specific pieces of that code apply. And what you, if you're asked, is this a reasonable view? You can say yes or no. You can stop if you think it's yes or no, but you can also then go on to explain what a court is more likely to interpret those words as meaning.
Just completely agree with everything Aparna said. I'd say that the majority of my work, probably most of the work in chambers, is assessing the statutory meaning of words. So looking at how they use their definitions, the context of the statute, purpose, all of those things are our bread and butter. For me, examples like the food legislation for VAT, the zero rating, meanings of confectionery, crisps, what even is a food, all of those things come past my desk on a weekly basis. And normally the accountancy firms, tax advisors already have a view. They'll already be aware of some of the case law, but we want to know, is it correct and how arguable is it?
Mm-hmm. I think that phrase you used there, what is a food, sums up the zero rating VAT legislation absolutely perfectly. The fact
that's my case next week.
Oh, is it actually? Interesting. If you want to solve any tax problem and be able to use HMRC guidance and tax legislation easily, then the Tax Research Masterclass could be exactly what you need. Head on over to thetaxprofessionalspodcast.com/masterclasses for full details. That's thetaxprofessionalspodcast.com/masterclasses. Take a look at the details and you can use the free business case that I've created to help persuade your employer to cover the cost and let you attend in work time. But if you're having trouble with that at all, feel free to get in touch with me and we'll see if I can do anything to help. Just one last put on the opinion piece, Aparna, and it's because you obviously mentioned initially that it's about giving, I suppose, definity in some. I don't think you use necessarily that word, but that's what I took from it. And obviously, because the fact legislation is down to interpretation in some cases, how do you then give someone like a definitive answer in something that is by its nature subjective?
Yes, so I didn't say definitive for a very good reason, because it isn't possible to be definitive for the reasons you've just given.
Yeah.
What you can do is you give what you think is the better answer, the most likely answer in the circumstances where the statute says this, the courts have interpreted the words like this, you know that the revenue has put out guidance that says something slightly different. So between the 3 or 4 sort of sources on which you base your view, you then give them what you think is the most likely view. But it's never really going to be definitive because, as you say, I cannot be the judge. I do not know exactly how a judge is going to interpret it and what they're going to consider to be relevant.
Yeah. I suppose really then what you're doing is trying to think what the judge would do, but obviously you can never know for sure, can you, how someone else is going to view something.
Exactly. And that's really, I think, why we call it an opinion.
Yes.
It's not a law.
Yeah. I suppose the only reason I'm pushing, is because I've seen a lot of what I would call naff opinions in my time where it's like such a small likelihood of that like interpretation being successful because it's super contentious, but then it's used as loads of marketing material, loads of people get brought on board because of it. And I think that's probably like the bad side of opinions, if you want to call it that, where some people probably take it a bit too far. And that's why I was just interested in getting the perspective of someone who is a KC on it.
Thank you. Yeah, I mean, I think that it's fair to say that there's that sort of opinion as well. And I think you need to, it is always a good idea if something is very contentious to test what is being sent to you. If you think, is this really how a court's going to interpret it? Even if it is giving you the answer you really need for this sort of planning to work, it's worth pushing back a little bit and just asking, can you just explain to me why you think that this view of yours is consistent with these things that a court might also take into account? So it's those, because an opinion is an opinion, which, and barristers are very approachable. And you can come back and say, look, can I just have a couple of queries on this point? You can do it very politely. And I'm sure there shouldn't be much difficulty with getting the barrister to explain their particular thinking on that particular aspect.
Yeah. I've heard as well, by the way, I'm sure you have too, about, I'm going to call it barrister fishing or opinion fishing, which is where people go around to hundreds of barristers until they finally get one that will agree with them and give them the opinion that they want.
Yeah, that's probably true too.
At what point should a barrister really be instructed? Obviously, it's going to change based on each of these circumstances. But let's just take litigation, for example. What is the optimum point to bring a barrister in, do you think?
I thought maybe if I start first and then Glenn and the others and Max can come in. Let's do litigation first. So you've put in a tax return, or you've sold something, you want to put in a CG return or something, and you put it in, and the revenue then send you a Section 9A notice to say, we're opening an inquiry into this aspect or the entirety of the return. Now, what you could do is as the accountant, just deal with it yourself. I would have said, though, that unless it's very straightforward, maybe the revenue just misunderstood an entry, unless it's very straightforward, you should really be thinking about contacting a barrister, instructing a barrister for their input. Because what will then happen is that you will be able to have a consistent approach to addressing revenue questions so that there isn't any discrepancy on which the revenue might be able to play. Mm-hmm. So I've said, when it comes to inquiry matters, come to a barrister as soon as you possibly can. But of course, often it's very that first bit, you don't know whether it's something really straightforward, or whether i.e. that the revenue really just misunderstood something you put in, or whether there's actually a much stronger underlying concern that the revenue had. So the first couple of letters, in my experience, at least about 2 or 3 letters, tend to be undertaken by the accountants or the solicitors themselves. And only then do they instruct barristers. And that's fine too, as long as at some point at a reasonably early stage, you start getting barristers involved, then actually they can assist maybe even towards settling the matter rather than, i.e. get the revenue being satisfied, rather than having to go down the ADR route or even litigate.
Yeah.
When it comes to advisory, of course, if you want to set up a trust for your grandchildren, or you want to set up an entrepreneurial structure in order to make sure you can attract investments through EIS relief and those sorts of things, then you should come to the barristers which are thinking of doing it with a sufficient lead time, so that because advice and restructuring can take a little bit of time. So you can have barristers come in at that stage as well.
Mm-hmm. This is always the thing that I found almost difficult, because up to the point you get to a court, there's many tax advisors out there that I would say are completely proficient in dealing with that and dealing with it, maybe not necessarily in the same way that a barrister would, but they would do a certainly good job of it. And that's why tax investigation teams exist, right, in like accounting firms, because they're not usually legally trained at all. They're just tax advisors dealing with like dispute resolution, say. And then obviously the barristers equally can deal with that. Do you think in reality that one is better than the other, or do you think there's just potentially different approaches and one might be better in a different scenario than another? Because I've seen both happen and I've seen both come out with good results in different circumstances.
Yeah, I get it. If I can just go first, and then Max and Glenn, please do come in after that. I see myself as working as a team, and I think most people in Devereux work collaboratively with those who instruct them. And so it's not a question of who can get the better outcome. It's a question of, can we get the best outcome for the client? And that can be by working with whoever's been working for the client up to that date and dealing with the revenue and dealing with correspondence. But on the basis that more and more things now come to litigation, just because of the LSS strategy, the revenues litigation and settlement strategy, it's probably a good idea to make sure that you get the barrister involved at some part of the way at a stage before it's impossible to try and settle.
Mm-hmm.
I would just add that I think the earlier, particularly with litigation, I think the earlier you can get a barrister involved, the better it is. You don't want to go down one avenue and then the barrister looks at it and go, actually, we should have done this, or we should have done X, Y, and Z. So I totally agree with the plan. I think the earlier you can get a barrister involved, the better, certainly where litigation is concerned.
I'd also only a very small point to add. I think everything else has been covered. But we appreciate that dealing with HMRC, having an inquiry or investigation can be incredibly stressful. I think there's a benefit for clients having that comfort from an early stage in knowing exactly the strategy and what they're going to do and how they're going to tackle and deal with HMRC right from the start. Maybe that's setting out a roadmap or setting out different costs and different stock-taking points so they can make sure that they really appreciate and have some sort of comfort when they're fighting HMRC or just trying to overcome and resolve an issue.
Yeah. I think like there's probably some scenarios where like a client doesn't have deep pockets, and to have a barrister and a tax advisor on their case working together might just not be feasible for them. And so in those cases, they're probably going to have to choose, aren't they? But I'm on board with you all in that if a client can afford it, then they should absolutely have both involved, because then they've got both perspectives, and surely that's going to result in something better than either one or the other dealing with it.
Well, I just very briefly, obviously Glenn sort of deals with the fees, so I'd leave that to him. But there are ways of ensuring that both can work for the client. It might be the case that rather than having the barrister draft those letters, they just review them.
Yeah.
There are cost-effective ways to make sure that you get the best possible service from your team. And now, maybe it wasn't the way traditionally, but now we barristers, especially at Devereux, as I said, we're used to working collaboratively, and we work as part of teams, and we all try to help out where we can. So it's not just the case of I instruct a barrister, expensive barrister, they'll do everything. There are scales and there are different ways to make it work.
Yeah, that's good to know, actually, because I would have thought that it was either like almost an all in or nothing approach in some cases, but it sounds like that's not actually the case.
No, that's right.
No.
Mm-hmm.
And the process to instructing a barrister is fairly straightforward as well. I can come on to that. So the process is actually quite straightforward. The tax advisor were doing ideally Devereux chambers and asked to speak to a clerk in the tax team. The clerk would then ask that tax advisor to outline the issues and which sort of level of seniority of barrister that they wish to engage with. They would also ask us other questions such as the urgency on the instructions, how quickly the advice needs to be turned around, or if it's a hearing, when the hearing is. The clerk would then look at the diary for members' availability and suitability to assist. At that point, they would then suggest a range of counsel that fits the criteria that they've asked for. At this stage, fees are not often discussed in huge detail. Fee estimates will be given ideally once the instructions are received and the selected barrister has had a chance to read in to gain a better idea of the level of work involved. Once the fees are agreed, the barrister will then start work on his or her advice. At that point, the terms of engagement are sent out to the tax advisor, and the barrister then carries on with doing the work, or indeed preparing for the hearing that they've been booked for. All the way through the process, there's sort of high levels of communication, and we're quite open and transparent in terms of liaising with the tax advisors. And ultimately, we're here to help them and place a barrister so they can resolve their issue.
Yeah. Do you know, in some ways, I don't know whether you think this is a fair description, but clerking then in that respect is somewhat like being a broker. But you're almost like trying to find the best barrister for the person that comes to you. And obviously you use the ones that are in your chambers and no one else, but just a word that sprung to mind as you were describing it then.
Yeah, absolutely. We're heavily involved in the process, and the tax advisor is reliant on us as professionals to provide options for counsel that meet their requirements, not just for the issues involved, but also the budget that they may have.
So obviously in terms of finding a barrister then, if they come to you in Devereux, then obviously you can help them find one from there. Do you think that's always the best way to go about it, is to pick a chambers and then go that way? Or how would you suggest people go about finding an appropriate barrister?
I think they can certainly go on various websites. They've got the Chambers and Partners directories and Legal 500 directories, which gives a guide as to which tax chambers they should use. I think that's quite a good resource. And once they've selected one, in tax chambers, there are, I would say, there's 15 to 20 tax chambers in London that all have good counsel. Obviously, Devereux, as I touched upon earlier, has got a growing team. And I think we've got a pool of members that cover quite a wide spectrum, both direct and indirect tax.
Yeah. In terms of KC versus non-KC then, I have a rough understanding of the difference, but I suppose maybe from you in particular, Aparna, it'd be good to know what really is the difference and who should someone choose, which one's right for them.
Thanks, Joe. I think that just so we understand the process, KCs now, QCs, when the Queen was alive, are appointed by an independent body. I think it's called KCA, the King's Council Appointments Commission. And what they do is they receive applications by people who are in practice who want to become appointed as King's Counsel. They go through a very rigorous selection process and then select some of those to be appointed. We've just most recently had a round, and we've had a new member of Chambers, Chris Stone KC, appointed this year. So we're delighted with that. What sort of things do the KCs do? KCs tend to, because of in order to get that accolade, as it were, the appointment, you need to have demonstrated that you are really excellent at litigating, at dealing with people, at being part of a team, at basically making good judgment calls when it comes to trying to achieve the best for your client. Now, you tend to find KCs doing more complex work, whether it's advisory or litigation. They tend to be people who lead, and I'll tell you what leading is, junior counsel, whether it's in advisory or in litigation. To lead junior counsel means that you are, as it were, the top of the pyramid in a team, which comprises you and other members of the bar, whether they're within your own set or whether they're not within your own set, but from another set of chambers, depending on what it is you need from your junior. So in some cases, you may have so many areas of law that are involved. You tend to have a junior specializing, say, in planning or in construction law, as well as a junior who is a tax lawyer, plus you. So it can depend on the number of teams. The number of people in a team can depend on what is required by the piece of work you're doing. And of course, it's not to say that only KCs do the best litigation. There are very good juniors who do excellent litigation and excellent advisory work, some of them in our chambers. So really, it's a question of what the issues are. Are they complex enough, in your view, to that you need to have a KC involved? If it's a big and sprawling piece of litigation, or if it's a very complex novel point, KCs seem the most obvious option, but that's not to say that senior juniors wouldn't also be able to do the job really well.
Yeah. I suppose really what you're getting with a KC is a bit more reassured that they definitely are going to be very good. As you say, there's going to be plenty of junior barristers out there that can do that too, but it's harder to know maybe than it is when the KC is a bit more, I'll say reassuring. I know I've said that word a few times, but that's the word that keeps cropping to mind.
Yeah. And also the point is that it's not a blind thing. You have resources to be able to work out who might be the best fit for you. Not all people are the same, and that's also true of ACs. So you might get on with somebody much better than you get on with somebody else. And that's very important when it comes to litigation as well, because you're going to be dealing with this particular person for quite a long time and quite intensely. So it's worth to make the time to get to know the people you think you might want to instruct as counsel.
Mm-hmm.
I think there's also budgetary issues there as well, because obviously Aparna touched on it in terms of leads, the junior coming in to do percentage of the work required at a lower rate is often quite a cost-effective way of dealing with it. So then the KC would then come in at the end with it and do a high-level review, as it were, and sign off any written work that may have been done.
Yeah.
I think we appreciate that the bar, certainly in terms of hierarchy, can be quite opaque. Unlike accountancy firms or solicitors firms where you might have trainees, associates, senior associates, junior partners, senior partners, managing partners. For the bar, you basically just have juniors, which is non-SIL, non-KCs, and seniors, which is King's Counsel. So there's obviously going to be quite some degree of variation within those two bounds. And I appreciate that for people who aren't dealing with litigation or barristers regularly, it might be quite difficult to work out who's going to be the best fit. Like we said, I think Glenn mentioned that the two answers to that. Firstly is go and speak to the clerks, because obviously they know the barristers are doing day in, day out. But also we've got the website profiles, articles that might have been written, and the legal directories, which are an independent source for ranking the barristers.
If there's a short answer to this question, by the way, why is the word silk used when it comes to KCs?
It's because the gowns are made of silk.
Okay, and you're not allowed to wear that until you're a KC then?
Yeah, I mean, they're shaped slightly differently. And yes, it's something that you get a chance to wear. And it's quite heavy, actually. Until what needs it.
Us lowly juniors have itchy cotton gowns.
Ones with big holes in.
Quite.
How I know you touched on this a bit already, Glenn, but then how do fees work then when it comes to instructing barristers?
So fees, every barrister will have an hourly rate, and often fees are calculated using the hourly rate as a guide. When calculating the fees, we tend to, once the instructions are in, which I alluded to before, members of chambers would then speak to the clerk and say, this is going to take 5 hours or 6 hours or whatever it may be. And then the fees essentially calculated on that basis. Now that is generally for written work or advising in conference or over the phone, when they can give a fairly good estimate of the hours that's going to be taken up. It's slightly different for litigation, where there is what we call the brief fee. Now the brief fee encompasses all preparation that the member will do and their attendance in court. There's it's not an exact science when it comes to calculating the brief fee, insofar as there's a slightly higher fee for a brief fee, because counsel are actually going to be on their feet doing advocacy as opposed to sitting in their room drafting an advice or an opinion. If that hearing is then a multi-day hearing, there is what we call a refresher fee, which is essentially their daily rate for days 2, 3, 4, or however long the hearing is set down for. The clerks and barristers here at Devereux are always pretty flexible with fees, and we try and tailor any fee estimate that we provide within the client's budget as best we possibly can. But as I say, we're always quite happy to be flexible on our fees.
Because I'm assuming as well, because it's similar in accountancy practice, obviously you can estimate how long it's going to take you, but you will never know up front exactly how long it's going to take you. So do you provide like fixed estimates, or does it change based on like ultimately how long we spent on it?
Well, the barrister then gives us a guide in terms of hours, and we'll agree that up front with a tax advisor. And if they want a fixed fee, so there's some certainty around the costs, we're very happy to do that as well.
Mm-hmm. Yeah.
Glenn, is it fair to say, obviously as self-employed barristers, we have to pay for our own insurance. The level of coverage goes up with very big, high-value cases. It's fair to say that one of the factors that the clerk will consider will be the value of the case as well. So it might be that a smaller case wouldn't be so expensive compared to some sort of massive, high-value litigation.
Mm-hmm. Yeah, absolutely. That's exactly right. And obviously that also depends on what level of seniority of member that the tax advisor wants to instruct.
Yeah, yeah. It's the same in the accounting world as well, because obviously you're looking at all the circumstances and then thinking what you believe is the appropriate rate for that piece of work and what's going to be involved in it.
Yeah. And often the negotiation is quite straightforward. We, as Aparna alluded to earlier, we like to see ourselves as a legal team and not just a different subsection, really. The negotiations can be pretty straightforward.
So then just a sweep up then, is there anything that we've not covered that you think tax professionals should know about instructing barristers?
Something else we actually discussed about prior to the podcast was that it's not uncommon for our barristers to give talks and seminars on legal developments, topics of interest, actually in firms or at their offices or hosting them in chambers. So when we're normally asked by the larger firms, mostly in London, if there's sufficient interest, we're more than willing to go and talk to smaller firms and organisations outside of London or to host them in chambers in London if they have something they want to hear about. It might be the case that it might be worth considering if they're seeing a similar issue that's repeatedly cropping up, for example.
Yeah, no, that's a very good point, Max. Absolutely. If one were to go regionally outside London, it would be worthwhile to host it in a sort of like a CIAG or an ICAEW branch office so that all the members of that particular body can come along to the talk there rather than come to London if they don't want to come to London.
Yeah. Where are the best places then for everyone to go to find out more about you? Obviously, you've got the website for Devereux, but what about you as individuals?
We write articles, and our cases. A lot of our work is already published in the reports. I think some of us have done 60 Seconds with the tax journals. Yeah, I thought those would be places to go.
Yeah.
The Chamber's website is always a good starting point. Personally, as a self-professed social media addict, should probably say that I am on Twitter and LinkedIn as well.
Yeah, I think actually the first time I came across you, Max, was through Twitter.
For better or worse, I'm not sure. But yeah, it's certainly a good place to keep up to date with various legal changes. I use it quite professionally rather than discussing what I had for dinner last night. But you certainly see up-to-date news articles and various cases and taxable developments. So I do recommend it, but maybe with a pinch of salt.
So thank you to Max, Glenn and Aparna from Devereux in this episode. Although I'm not a history fan, generally speaking, I did actually find the background behind the cab rank rule and why the word instruct is actually used. I found that interesting. I also had no idea about the cab rank rule until this episode, so that was something new for me to hear about too. I would say the key points for you to take away from this episode are the following. So 1, instructing is the barrister equivalent of a client engaging with a tax advisor. 2, tax barristers don't only defend taxpayers in tribunals and courts, but they can also provide advice and opinions to give clients more certainty too. And 3, when finding and instructing barristers, you'll be interacting with a clerk who will help you find an appropriate barrister and deal with all fee negotiations. Show notes for this episode are at thetaxprofessionalspodcast.com/TTPP95. All links mentioned throughout this episode are included in the show notes, plus there are also links to the profiles of each guest, along with a link to the Devereux website. I've also added in as well a link to Max's LinkedIn and Twitter, but just remember Max doesn't post about food, so if that's what you're interested in, stray away from his Twitter. There's also a link in the show notes to the Tax Research Masterclass, where I teach tax professionals how to find the answer to even the most complex tax queries. And if you enjoyed this episode, you can sign up for email notifications to make sure that you don't miss out on any future episodes. And episodes are bi-weekly and are released on Mondays. To sign up for those email notifications, head on over to thetaxprofessionalspodcast.com/subscribe. There's a link to that too, also in the show notes. But that's this for this episode. I hope you found the episode useful and have taken away some useful points to help you to progress, develop, and improve your tax career. Until next time.